Hello, welcome again to Law in Depth. My name is Femi as usual, and I have Phil with me as always. This is a continuation of the previous episode of workplace bullying and psychiatric harm in the workplace. And just a bit of a take back. In the previous episode, we talked about three doors when tackling psychiatric harm in the workplace. We talk about the fair work pathway, which is preventative, essentially to stop the act from continuing. And we'll talk about the work health, safety, and the criminal pathway. And we also talk about the common law negligence, which generally is fault based and compensation applies. The only thing about this is that it's relatively difficult to establish the pure psychiatric harm because it requires proof of causation. Across all these three pathway, the themes that are consistent is that there has to be sort of repetition, there has to be foreseeability, and there has to be a failure to act. Now, what actually counts as recognized psychiatric injury in law, and how do courts distinguish between stress and something legally compensable, and where does the older doctrine of nervous shock fit into all of this? And that's where we are heading in this episode. And Phil, let's take back to the first principle. In common law cases, you often see the phrase nervous shock. What does that actually mean, and why does it matter in workplace claim?
For me, there's trying to be a wide range of recognized psychiatric illnesses. We have phobic anxiety, neurosis, post-traumatic stress disorder, or PTSD, and this label is misleadingly inaccurate because it disguises a serious form of damage with elements of greater subtlety than ordinary physical injury.
So, what would you call or what would you classify as a better framing?
The courts nowadays have recognized that this label is misleadingly inaccurate. The phrase nervous shock, they have considered it to be psychiatric illness or psychological or psychiatric injury. So the harm has to be the result of emotional stress and not merely the emotional stress itself. And this illness does not have to persist until symptoms come. It could have already been resolved and still be compensable.
So there's a distinction between primary and secondary victim in this area. This I know trips people up.
That's right. So a primary victim is somebody who has experienced a shock in respect of their own safety. So in the previous episode, we talked about the mine flood happening. Those persons who had survived, they were participants in that event. And so the test for liability, well, the test that applies when somebody's primary victim, that's simply the reasonable foreseeability of the personal injury. And secondary victim, they are non-participants who usually experience shock in respect of the safety of others. So, for instance, a near-miss incident happening at work and somebody else was getting injured, but you had no risk to yourself, that becomes you become like a secondary victim, and they would face a more complex.
So, in the workplace, which category does the bullied worker fall into?
So the bullied worker is usually a primary victim, and this matters because they don't need to clear that additional step that secondary victims usually have to, which are proximity, the closeness of relationship, or and so on and so forth.
So, what do you have to do to succeed in this claim generally?
This is a very difficult topic. Usually success in litigation is a matter of chance. But the claimant usually has the duty of care situation. Then you have the breach of that duty of care. So you have to show the defendant has breached that duty. There's a causal connection between the breach and the damage. So you have to show that the damage was caused because of the breach. And then you have now the other obstacle of showing that this damage was foreseeable and reasonably foreseeable for that matter. And fifthly, the damage has to be attributable to the defendant, foreseeable. And fifthly, the damage has to be attributable to the defendant. It can't be like intervening parties in between before you want to claim in negligence. And then lastly, the damages have to be quantifiable, which means the court has to see some form of loss or other kind of loss that has been occasioned to the plaintiff, but that can be quantifiable in terms of.
And you think that these elements is often present in many psychiatric cases?
That's right. So they do, and the courts usually deal with the foreseeability questions first, but usually that's like a threshold question, and then they consider duty and breach after, as well as causation and remoteness. So policy considerations could also come in, and this would lead a court to limit the liability, even where foreseeability has been established.
Mm-hmm.
Yeah.
Foreseeability seems to keep coming up. I think
Yeah.
we've talked about foreseeability for a while now. So how should we think about this foreseeability?
Okay, so the thing is, in psychiatric harm claims, foreseeability is necessary, but it's not sufficient. So this means that it's not the only factor that's considered. So the damage must be of a foreseeable kind, meaning, obviously, I've said the reasonable person would not brush aside. However, courts approach foreseeability of psychiatric damage from question of common sense, meaning progressive awareness of mental illness. That question is considered by the courts. So it's both a question of fact and law. So there's a legal test, there's a factual test,
and the precise nature of injury.
Yes.
Foreseeability is not the only factor. It's a question of fact and a question of law.
Right. It's a mix. Yeah. So another thing that we can discuss, or that I find to be quite relevant in this topic, both psychological or psychiatric injury, is that there has to be understanding. We have to understand the difference between actual condition and now the other conditions that we think that we've experienced. So the clinicological side of it, which also sometimes falls under the threshold questions, is very important. And sometimes we think that because I'm facing grief or I'm worrying because of an incident that's happened at work, whether it's to, for instance, if it's to another person, then we sometimes think that that's automatically a psychiatric condition. However, this is not the case at law. So there's a distinction between the conditions that arise from grief.
So can you speak more around that distinction in terms of conditions that may arise from worrying versus conditions that may arise from grief, and why does that really matter?
So it used to be the term nervous shock was used when somebody would experience hardship in a challenging situation at work, near miss incidents. Sometimes this would also happen if you're a police officer or an ambulance driver. And so the fright and horror that somebody could experience, usually and traditionally, you could recover those damages in court. However, grief-induced conditions were usually not get compensation in court. So grief alone is not recognized as a psychiatric illness in the compensable sense. The harm has to be more emotional upset or unhappiness. It has to be a clinical condition.
Pinning it down to workplace. So, and in workplace claims, how does that come in?
So, in practice, conditions that workers develop from sustained bullying include major depressive disorders, anxiety, PTSD. These are recognized psychiatric illnesses. Mere grief, however, is not one of those, or unhappiness is not one of those conditions. And like I've said, I've given a few examples that some of these conditions could arise in. I'm not saying that they're all-inclusive. There could be other instances where one work injury that you've received has led to another injury, psychiatric kind, also being around. Usually the two would go hand in hand, but not always. Yeah.
So it's not being unhappy. It's not a recognized psychiatric illness.
No.
Just for our listeners to unhappiness would not cut it for under psychiatric illness. And that brings to a principle of eggshell skull. Do you mind to speak a little bit about that?
Eggshell skull rule means, so the eggshell skull rule, pretty much you have to take the victim as you find them. So the employer, and you have your worker who had a personality disorder, and you've employed them as a police officer, and somehow through the work conditions they experience or they have these psychological risks that materialize, and they end up with a psychological injury or disorder or psychiatric injury, that in itself does not take away your liability to the employer. And
Yeah,
this,
and that's a valid point because
yeah,
employers sometimes try to argue that the harm was caused by
yes,
workers' pre-existing fragility rather
yeah,
than the bullying itself.
that's right. Usually, the question of liability now be that where the dispute would lie, and sometimes if the employer has put in enough support measures, and usually they have this, they get back to work sort of like remedy, where the employer has to bring back the worker and have conditions that are suitable for them to get rehabilitated into the workplace, then usually the question of damages is, can get reduced if they've already put in the reasonable systems where psychological risk has been reduced. So, but nonetheless, the only place that this would have an impact is in the quantum of damages. So if somebody still suffered a psychiatric injury at work, and usually we have those a lot of times in the first responders are usually up there in terms of the likelihood for the foreseeability of psychological injury happening. So usually it changes the question of quantum of damages, which
Mm,
is much the court can.
yeah.
Yeah.
And speaking about that quantum, about the quantification,
Yes.
essentially, because it's a bit more subjective in a sense. So, what does
Right.
compensation look like in these claims, and how do the court will put a number on
Yeah.
psychiatric harm?
So this is it's a challenging question. Usually, it's hard to say how much somebody's pain is worth, and so there's a lot of questions that the court asks itself. But usually, the goal is to try and to restore the plaintiff to their position before they received this injury as nearly as possible. For psychiatric
Mm.
harm, this is like hard to quantify and say this is where this person was or what's worth this and this
So
money.
essentially, yeah. So
Yeah.
essentially, the award is essentially unpredictable because
Yes.
you have to find a way to restore the employee or the defendant
Yeah.
back to the original. Sorry, the plaintiff back to the original state they were before the injury.
That's
And I know some nervous shock cases. There's always a discussion around.
yes.
Essentially, what
Yeah.
that means is it means
Right.
everyone can put in a claim, and it doesn't really make sense in the long run. Is that a concern in workplace psychiatric injury claims? You
Usually in
reckon?
workplace cut is the requirement for that diagnosed a psychiatric illness. So and then this has to be cases that usually go into the courts, not for them to determine whether somebody should receive.
Mm.
Yeah.
Mm.
But
And yeah,
generally
so it
they
means there's a limitation.
yeah, so they filter out the grief claims. A lot of people come in the grief claims for the mere unhappiness. They're not happy at work, and usually that doesn't meet the threshold that's required for an award. Yeah,
So, just can we talk about the limitation period as well in
yeah.
terms of how long it can take you to bring a claim, or what the court expect when the court expects you to bring a claim forward?
Generally in WA, I think the limitation period is longer here than in other states. We have 6 years for tort actions, and these
Mm.
claims, usually the work health injuries, fall under negligence cases fall under the tort types. And so usually the period that the court calculates that time, that 6 year window, starts from when the damage
Mm.
actually been suffered by the plaintiff. And but for psychiatric harm, it doesn't start, that clock doesn't start till the damage has been suffered, or if the person knows that they have suffered that damage. So sometimes that's usually a bit of a nuanced way of looking at it, because in general negligence cases, you'll know that your car has had like an, but when it comes to psychiatric injury, sometimes you don't know. So that clock has been extended until the point that you know. So usually when you get that diagnosis, yeah. But the initial distress that you suffer usually doesn't start. So it's usually like a long-term condition that the courts are looking for. Femi, if somebody is going back and looking at our production, what should they take away?
Yes, just for our listener, please remember nothing in this episode is a legal advice, of course. For specific situations, always get in touch with your lawyer or legal counsel that will also provide you with specific advice. But generally, the headline principle you'll be looking at in all these, I'll sum them up in five. And the first one will be the Fair Work Commission test, the test which is objective and cumulative. So you'll be looking at repetitive, unreasonable behavior that creates a health and safety risk. Just to contrast that with performance management, if performance management is done lawfully, it cannot come under repetitive, unreasonable behavior. So performance management done lawfully and execution is also reasonable. Of course, that would not pass the test of the Fair Work Commission. There's quite a number of cases. Mac, which we've discussed in previous episode, comes to mind when you discuss this principle. The other one is the work health safety law consideration or principle. Uh, this sort of shows that the duty of an employer extends to psychological health, not just safety, physical safety. Employers who build system or cultures that foreseeably expose workers to psychiatric risk and fail to act generally face criminal liability. We've had some case laws as well that sort of confirm this principle, and not case laws which we also discuss in episode one. And thirdly, we look at the common law principle, which sort of provide that a sustained abuse conduct combined with managerial inaction gives rise to negligence liability. The employer does not need to have cause to bullying itself. Their failure to act in this instance in response to breach will pass this test generally. And fourth is the foreseeability of psychiatric harm is generally assessed physically, practically. You cannot argue you didn't foresee the specific diagnosis. The condition made some form of psychiatric harm foreseeable. That's sufficient. Essentially, if that condition made some form of psychiatric harm foreseeable, if you create a condition that is foreseeable that this could cause psychiatric harm, that will be sufficient. And lastly is the pre-existing vulnerability in workers does not defeat liability. So if they have that existing condition before, you're not generally off the hook with liability essentially. So an employer takes their workers as they find them, like Phil rightly mentioned earlier in this episode. Of course, vulnerability may affect the quantum of damage, but that's not the underlying duty. And
For somebody who has a potential situation that could be unfolding, what do you think the steps that they can take not to shield themselves in case they're in a situation like this, or in a bullying situation, or they have a suspected case of psychological psychiatric injury?
yes, so document everything. Document everything. Also, medical evidence is central to proving your point. The diagnosis of psychiatric illness is also very important. Not just stress or you merely upset. The case cannot be built on you're just upset or you're stressed. Also, know which door you are going through. We mentioned couple of doors. We mentioned three doors earlier on. So you have to know the doors you're going through. Fair Work Commission, if the bullying is ongoing and you just want it to stop, then that's your door. That's the door you have to take. In terms of negligence of the harm that has already been suffered and compensation is your goal, you'll be looking at negligence. But again, the advice early, legal advice early. We're saying it's not legal advice, but you do need to get in touch with your lawyer and have this discussion and advice early, and you know what to do moving forward.
Pooja, let's wrap up episode 2, more in depth. covered the Fair Work Commission's anti-bullying jurisdiction, work health safety, and the criminal liability, and as well as the common law pathway for psychiatric injury and negligence, including how the so for
Yes. And before we close, so just to speak more to the steps that I talked about earlier.
yeah.
So to land all this, if you're watching this right now and something about this conversation feels familiar, what you need to do, step one, is to document everything. Date, what was said, who saw it, how it made you feel, not for you, but for evidence, because the law requires patterns and patterns need proof. So you need to show evidence in your documentation. And also, you need to report this internally first and document that you've reported this as well. Keep your email trail because one of the things that the court that could sink the employers in court is when they cannot show they responded to a complaint. If you report it and nothing happens, that inaction in itself is also or can become a liability in the long run. Like I mentioned earlier on, get diagnosis of psychiatric injury. You can take it to Fair Work Commission if you want the behavior to stop. Essentially, get in touch with your GP, get your mental health documented medically, because psychiatric injury claims are won and lost on medical evidence as well. And to employers, just think about what you do. You put this in front of your mind when you coordinate activities of your workers, because people or employers think this is soft, but an $800,000 criminal liability or penalty and personal conviction for the directors is not soft. I mean, that's the entire business. Yeah, so that ends what we have to say today. Phil, anything to add?
Maybe you're not being too sensitive, you're not overreacting. What has happened to you could have a name, and the law sees it, even if your employer has pretended they haven't seen it. That's right. So let's see you on the next episode.
Yeah. Yes. Thank you, everyone. Thank you for sticking around, and click like and subscribe. We'll continue to do this as much as we can, different topics. Anything that happens, you might think it doesn't have a name, eventually it does. We'll be here to cover most of them. So stick around, and we'll see you in the next episode. Thank you.
Okay.
Back. Cheers.